Hey, I'm Bonnie Ross, and I've been an estate planning attorney, and I've taught at Hastings College of the Law and USF Law School, teaching wills and trusts and estate planning and estate and gift tax. And I'm going to give you a background to help people so you can help people planning for death. This is going to be a very condensed summary of wills and probates and intestacy. And I'm going to jump right in here with a question. So if we can have the next slide. So what do Abraham Lincoln, Aretha Franklin, and Kurt Cobain have in common? Well, if you guess they all died without a will, then you're right. When celebrities die without a will, it makes headlines and it often leads to lengthy litigation. But it's not just an issue for the rich and famous. None of us likes to face our mortality, and that's a problem. So over half of adults don't have a will. Why does this matter? Well, if you don't, you can look at it this way. If you don't have a will, the state of California writes one for you. The California intestacy laws, Probate Code 6401, governs what happens to your property if you don't have a will. It generally provides that that there is a proceeding called a probate to oversee what happens with your property. The goals, and next slide. The goals of probate is for the court to ID the assets, to appoint fiduciaries and guardians for the children, to create an opportunity for creditors to get paid, and to make sure that property goes to the proper person. Remember to state the obvious, at the time this is all going on, the individual whose property it is dead. And so she can't speak up and say what it is that she wants or what she intended. Of course, the intestacy rules and probate are based on a bunch of assumptions about people's values and relationships. The problem is that these days, it's common for those assumptions not to hit the mark. So here's the next slide. The laws were designed for the June and Ward Cleaver family, from Leave It to Beaver, a nuclear family, one marriage, maybe a couple of kids. The next slide. Next slide. Here we have sort of a basic overview or summary of what the most important parts of the intestacy laws are. There's not time to actually get into detail because these are just a few points of it, and it can get very complicated. Sometimes the intestacy laws get it more or less right. If you, like the Cleaver family, are married or in a domestic partnership, have a domestic partnership agreement, and this is your only marriage, and you have 2 kids, and all your assets were earned during the marriage, and you and your partner have the same intention that the death of the first of you, the property will all go to the other, and then at the death of the second of you, it'll all get evenly divided among the children. It may work out okay for you, but often the intestacy rules don't fit the way life is today. A lot of people are not living the June and Ward Cleaver life. Next slide, please. So what can go wrong under the intestacy? Well, here are a couple of examples I have listed here. Again, I'm not going to go through all of them because we don't have the time, but I'm going to touch on 2 of them. One common problem is the situation when couples aren't married. You could have been in a committed relationship for 30 years and have children together. But if you're not married and you don't have a domestic partnership agreement, when one of you dies, the other will get nothing. Property might end up going to a distant aunt or a cousin once removed, rather than the partner you've built your life with. That's because other than property going to a spouse or a domestic partner, under the intestacy laws, property can only generally go to blood relatives. So if you're not a blood relative and you weren't married and didn't have a domestic partnership agreement, when when one of you dies, 0 goes to the other partner. California does not have a common law marriage. I'm going to repeat that because I think most people think the opposite is true. California does not recognize common law marriage. And that's a big deal these days because cohabitating non-married couples tripled in the last 20 years. A second problem that can come up under the intestacy laws that you see listed here is the situation of a blended family, where all the children are being raised as siblings. You can think of, the Brady Bunch TV show from the 1970s. If you remember, there was Mr. Brady, he is widowed with 3 boys, and then there's Mrs. Brady, who's divorced with 3 girls, and they get married, and they are raising all 6 children together as though they're siblings as one. But if, let's say, after 20 years of marriage and after accumulating their assets, Mr. Brady dies, and he dies without a will, all the property at that point will go to Mrs. Brady, which is probably what they intended. But if by her death, if she hasn't created a will, then all the property, both the property earned by Mr. Brady and Mrs. Brady, will all end up going to Mrs. Brady's daughters. The 3 sons will end up getting nothing, even though that isn't the intention. The intention in that situation would have been for the 6 children to share the property equally. So these are just 2 of the examples of why it's important that we have wills. We can go now to the next slide. Next question that you might have is, who can make a will? Well, the fact is most adults can, you need to be 18 years old and you need to be of sound mind. But being of sound mind just means that you need to be able to understand the extent of your property, understand the nature of making a gift at death, understand the nature of a testamentary act. And the third thing is to understand your general relations with people. Next slide. So beyond these competency requirements of being 18 years old and being of sound mind, what's required to make a will? Well, in order for a will to be valid, it depends on what kind of will you're making. There's basically 3 kinds of wills that we have in California. There's attested wills. These are attorney drafted wills. They're generally typed. They're prepared by an attorney. They can be very sophisticated, involving trusts and lots of tax planning. They can be tailored exactly to the needs of the individual. The problem with these wills is that they can be expensive. Not everyone has the money to go and hire an attorney to make a will for them. And even lots of people who do have the money really don't necessarily want to spend it for an event, their death, that they're hoping isn't going to happen for many decades. So attested wills have their problems. The next kind of will is a holographic will. Holographic wills have the fewest formalities. They're handwritten and they're generally not witnessed. The problem with them is that there's the least certainty that they will be considered valid. You maybe remember from back studying for the bar exam, the examples of, somebody writes on the side of a tractor, in their handwriting, "This goes to Billy Bob on my death." And you get to the question is that a valid will? Can that be enforced? Well, it's a little unclear. So because of the uncertainty of whether or not a holographic will be considered valid, and generally the question of validity comes down to whether they really intended it to be a will or not. That's the biggest question that comes up. But because there's that uncertainty, we generally do not encourage people to create holographic wills, except in the situation where there's an emergency or it's being used on a temporary basis. For example, if someone has to go into the hospital for emergency surgery. The third kind of will is a statutory will. And in California, there's the statutory will is created under Probate Code 6240. The language in the will itself comes right out of the code. It's a form with instructions, and there are blanks and there are boxes you fill in. It has to be witnessed, but there are two big benefits of these wills. The first is that they're not expensive to create, unlike the attorney attested wills. And the second is that if you follow the instructions, as long as you follow the instructions, there's no question that they'll be accepted as valid. So they don't have the problems that you see in either the attorney attested wills or the holographic wills. At our clinic, we're preparing statutory wills because of these benefits. Before I dig in a bit deeper into those statutory wills and how they need to be completed, I want to talk a little bit about the kinds of assets that can be transferred by will. The kinds of assets that can be transferred by will are called probate assets. Next slide, please. So as you can see here, I've broken assets down into non-probate assets and probate assets. I've been talking now about probate prior to this, about probate and transferring assets through probate, either through a will or through the California statutory intestacy laws. But not all assets go through probate as at the deceased step. Some assets transfer automatically without going through probate. That's because the assets are held in a way where it's dictated what's going to happen at the person's death, at the owner of the property's death. This can be because the assets are held jointly with another person in a way that ownership itself dictates what's going to happen to the property. So for example, held in joint tenancy or as community property with right of survivorship, so that when one owner dies, it automatically transfers the whole of the property transfers to the other partial owner, so that the survivor owns the whole property or owns that joint tenant's share of the property also. So that's one way that property might pass not through probate and be a non-probate asset. A second way is if the property is held in a trust and the trust names and designates the beneficiaries. Another way is if the title to the assets designates the beneficiaries. So generally, life insurance you'll designate a beneficiary who will get the proceeds of the life insurance. IRA and other retirement accounts generally have a beneficiary designated. And as long as you don't write your beneficiary designation as to my estate, then it will go not to your estate through probate, but rather directly to the people or person that you name as the beneficiary. In addition to that, non-probate assets can include assets in a bank or brokerage account that has a transfer on death clause, so where the account itself specifies who the beneficiary should be. Here in California, we even have what are called transfer on death deeds, where on the deed to a residence itself, it can say who the beneficiaries would be and who would get it if the owner of the title to that property dies. So all these assets that I'm describing now are assets that are non-probate assets, and they will transfer automatically at death. They'll not pass under the terms of a will, and they won't pass by intestacy. It's one important thing to recognize is that non-probate assets retain their character as non-probate, even if the owner subsequently creates a valid will. A will does not override or change how title is held to these assets. It's really important for individuals who are making a will to understand this point, because it's understandable why they might think that if they create a will after they have acquired these assets, and after they had designated the beneficiaries on those assets, that they might think the will would override it, since the will is the latest document they're creating. But that's not the case, and it's important for them to understand that. So we can see from all this, there's the potential to transfer assets and avoid probate. And that actually can be a good thing, because while probate has legitimate goals, that we talked about at the very beginning, of identifying the assets and appointing guardians and making sure creditors get paid, and ultimately making sure that the property goes out to the proper beneficiaries. While probate can have legitimate goals, there's a reason that probate has a bad rap, and why you really can't watch TV at 2 a.m. without coming across an ad for how to avoid probate, in a very excited manner. And it's because the probate process can be long and time consuming. It can be expensive. Sometimes it can seem really unreasonably expensive. Next slide, please. Because probate fees are set as a percentage of the value of all the deceased assets, undiminished by debt, probate fees can be high in relation to the value of the estate net of those debts. So for example, here's a slide with this example. If an individual owns just one asset, say a residence worth $1 million with $800,000 of mortgage on it, so there's only $200,000 in equity, the probate fees on that could be as high as $46,000, almost a quarter of the $200,000 of value net of debt, almost a quarter of the property that would otherwise go to the beneficiaries. It's not unusual in Marin, or really anywhere in the Bay Area, to find one asset, usually a home, that's encumbered with a lot of debt on it. So this is a real issue for people. And in helping clients, we need to be aware of them often having an interest in trying to avoid probate because of these fees and the time it takes to get through probate. Towards this end, one thing that can be helpful to clients is the simple probate affidavit. If the total of an individual's probate assets are below the simple probate cutoff, their beneficiaries can avoid the time and expense of a full probate by just filing an affidavit. For 2022, that cutoff is $184,500. So if a probated part of the estate is under $184,500, they can just avoid a full probate and just file this affidavit. One strategy, therefore, in representing clients, is to help them see ways to bring down their probate assets under the small estate cutoff. And when it's appropriate, and this could be true when if you have assets recharacterized so that they are held in joint tenancy, or as community property with right of survivorship, if that's appropriate, or possibly to change an account so that it's an account that has a transfer on death clause with a beneficiary designated. So these are ways, and we want to consider this. We want to think about ways that we can help the clients bring down their probate in this manner. Turning back to the statutory wills that we're going to actually and assets that are probated assets. Let's go to the next slide now. Here is the first page of the California statutory will. I'm not going to go through line by line. We just don't have the time to do that. It comes with very clear instructions, but I'm going to highlight a few things that I think are the most important points for you to be aware of as you're working with the statutory will. The most important is that these are forms. They have blanks and they have boxes filled in. If you want to go to the next page, you can go to the next page, the next slide now. You'll see it continues in the same way. And you can go to the next slide also. You can see it's lots of slides, blanks and boxes to fill in. This is what's important to know about this form. You cannot add options. There are options that you're given. You have to choose one of those options if you're going to use this form. You can't add options. You can't add language. You can't delete language. The statutory will is a very simple will with limited choices, actually. And if none of these options work for an individual, then this statutory form may just not work as a will for that individual. They may have to go in another direction to do their estate planning. Because if you try to add language to this or delete language from this form, then it can invalidate the whole will. So whether or not this will is going to work for an individual client is going to just depend on whether or not these options work. In particular, the statutory will puts limits on how assets can be split among groups of beneficiaries. A person making a statutory will can leave a stated amount of cash to a specific designated person. They can do this with several people or several charities, give them a stated amount of cash. But other than giving a specific stated amount of cash, the only way that you can distribute property give property under a statutory will is giving property to one of four classes of beneficiaries. And that is either, the first is all to the spouse or domestic partner. And if the spouse or domestic partner has predeceased, then equally to the children. Or if one of the child has predeceased also, then the descendants of that child. But generally, it's either the first option is all to the spouse or domestic partner, and if there's no spouse or domestic partner, then to the children equally. The second option is nothing to the spouse or domestic partner, and everything equally to the children or the descendants of a predeceased child. The third is all the property goes to one person. And the fourth option is all the property gets evenly divided among several people who are named, who are designated. You can make this decision in terms of who the property goes to, which of these four categories separately when it comes to the residence and the personal property, and finally the residue of the property. So you could give all to one individual your residence, and then you could give divided equally among the children, the personal property, and give the residue of your property all to your spouse or your domestic partner. But those are you see those four choices of beneficiaries among each of these categories of residence, personal property, and the residue of the property. So, for example, you could not decide to give under either your residence or your personal property or the residue of your property. You could not choose to give it all to your children unequally. You couldn't give 60% of your property to Joey and 40% to Evelyn. That's not going to be allowed. It has to all go equally to the two children, even if there's a valid reason why Joey might need it more. He may have more needs, but that's not allowed. Again, the statutory will is a very simple will. There's just two more points that I wanted to touch on here. One is if we go to the next slide, where it comes to nominating the executor there at the bottom, you'll notice that it says if an individual does not want their executor to have to post a bond, they have to sign in that box. most people who are appointing a family member or a close friend as their executor, they don't want them to have to take on the expense of posting bonds. So that's something you definitely want to talk about with the client. And there's, and most clients end up deciding to sign there. And then the final thing, if we go to the very last slide here, when it comes to executing the wills, again, there's instructions. I don't need to go through it step by step, I don't think. But the will maker, needs to sign it and date it. There needs to be 2 witnesses who must sign and date and make a declaration that is stated right there. You have to read that printed declaration that the statutory will was made by the will maker. So and that the witnesses have to say this, and the witnesses have to attest to their own competency also. So that's about it for when it comes to wills. I think that you're going to find that most people are tremendously appreciative of you helping them through this process. Again, people are not comfortable facing their mortality, and you're helping them do that and do something they know that is the responsible thing to do, to take care of this. So again, it's just such a pleasure to be able to participate in the Legal Aid of Marin estate planning clinic. And that's about it for me. I'm going to hand it off to the other half of this Bonnie and Clyde team, who's going to talk about planning for incompetency during life. So thank you. Work with Legal Aid of Marin. So, okay. So I'll just start right in here. So I'm going to be giving sort of well, actually, why don't you introduce yourself, Clyde, too, then, and then we'll go back and I'll start rather than doing the introductions.
Thank you, Bonnie. That's great. So my name is Clyde Charlton. I'm an attorney. I do wills, trusts, trust administration, elder law, and probate here in San Rafael, California. And I participated in the previous clinic as well. And so we're kind of doing a reprise here by doing another training for a new set of volunteer attorneys. And I just wanted to thank all of you for donating your time, energy, and attention. So I appreciate that a lot. Thank you. That's it.
Then I will start. Okay, I'm going to give sort of a whirlwind summary of wills and probate and its intestacy. And I'm going to start it all off with a question. And so you can go to the next slide, Gabby. Okay, so what do Abraham Lincoln, Aretha Franklin, and Kurt Cobain have in common? It looks like somebody is raising his hand. Nathan, do you know? Just are they all do I have to unmute them?
Oh, I can actually that was an accident. I attended the last training, so I already know the answer if you wanted to.
Oh, okay. I thought you were okay. Well, anybody else? Okay, who else there? Darren, what do you think they all have in common? And there's a big hint because of the subject.
They're all Americans, but I suspect what you were looking for is they all died without a will or trust.
That's correct. That's exactly correct. And they did. And when famous people die without a will or trust, there's usually big headlines, and often there's lengthy litigation that follows that. But this isn't just a problem for the rich and famous. None of us like to really face our mortality. And so and that's a problem for people. Over half of adults don't have a will or other document that provides how their property should pass when they die. So you could ask, why does this matter? So the bottom line is, if you don't have a will, the state of California writes one for you. The California intestacy laws govern what happens to your property when you don't have a will. Generally, when someone dies, there's a proceeding called a probate, and it has some legitimate purposes. It identifies the assets, appoints a fiduciary to manage the property, and appoint guardians for minor children, and make sure it's to make sure that creditors have a chance to get paid, and then ultimately make sure the property goes to the proper beneficiaries. Remember that when the assets are being transferred, the testator is dead, completely dead. So there's no possibility that she can speak up and say what she wants or wanted with her property. So it's valid that we would want a court proceeding and that we need rules. And as you'd expect, these intestacy rules are based on assumptions about what people's values are and what people's relationships are. The problem is, these days, it's common for these assumptions just not to hit the mark. Because you can go to the next slide. Sorry, I actually skipped one. Okay, yep, sorry, skip 2 there. Okay, should we just start over here? Okay, I'm caught up. Sorry, here. Assumptions. There are assumptions about what people's values and relationships are, and the problem is that the law doesn't reflect really the way people live these days. It was really designed for like the June and Ward Cleaver family, a nuclear family with one marriage, maybe a couple of kids. And it's not to say that the intestacy laws never work. If you're in a domestic partnership or you're married and you have been for many years and you have 2 kids and all of the property that you've earned was earned during the marriage, and both of you want the property to go, you and your partner each want the property to go to the other one when the first one dies, and then ultimately to all go and get divided equally among your children, then the intestacy laws may capture what you want. But the problem is that these days that doesn't describe many people. You can go to the next slide. So I can't go into detail about all of the intestacy laws. There's just not enough time. But one basic underlying principle of the California intestacy laws is that other than property that goes to a surviving spouse or a domestic partner, it generally can only pass to blood relatives. So again, if you're not married and you don't have a domestic partnership, you don't get your partner doesn't get anything under the intestacy laws. California does not recognize common law marriage. And I'm going to actually repeat that. California does not recognize common law marriage. And the reason I'm repeating it is that I think that most people think the opposite is true. And that causes problems. So, like, for example, what could happen under the intestacy laws? Well, you could be in a committed relationship again for these 30 years, but never get married and don't have a domestic partnership agreement. And, the person won't get anyone. It could go to a distant aunt or a second cousin once removed, rather than going to your actual partner. Take another situation. If you have a blended family, if you can, new slide. Sorry, I'm not on my game here. So these are some of the problematic situations. So I did the first one. You could be married for a long time and it won't work for you. A second one there is the blended family, where all the children are being raised as siblings. You could think of like the Brady Bunch, from the TV show from the 1970s. You had Mr. Brady, and he's a widower with 3 boys, and he marries Mrs. Brady, who is divorced, and she has 3 girls. But they're raising all of these children, all 6 of them together as siblings, as one family. Well, if after 20 years of marriage, Mr. Brady dies and he doesn't have a will, well, the property will all go probably to Mrs. Brady, which may be just what they want. But if she doesn't make a will then after his death, before her death, then the property will all go to the 3 girls. The 3 boys will get nothing because they're not her blood relatives. And so you have this situation that is just so contrary to what the people involved would want. So that's generally why, it's important for people to have wills, because if you're leaving it to the intestacy laws, it's just not clear that you're going to end up getting what you want. Next slide. So what does it take to make a California will? Well, not very much. There aren't a lot of requirements, actually. You have to be 18 and you must be of sound mind. And all that means is that you need to be able to understand the extent of your property, understand the nature of making a testamentary gift, a gift at death, and you've got to be able to understand your relationships with other people. So it's a very simple requirements for making a will. If you can go on to the next one. Thanks, Gary. There are different kinds of wills. There are basically three kinds. One is what we call the attorney drafted attested wills. And they can be quite sophisticated. They can involve trusts and lots of tax planning, and they can be tailored exactly for what the people involved want. That's all good. The problem with it is they can be expensive, and some people just don't have the money to be able to get a will drawn up, or even many who do have the money don't want to spend it on an expensive will for an event, their death, that they're hoping isn't going to happen for many decades. So, that's an attorney attested will. There are holographic wills, and holographic wills have the fewest formalities. They're handwritten, and there are no witnesses. The problem with holographic wills is that there's the least certainty about the validity of those wills. You may remember from studying from the bar, learning about examples of somebody scrawling on the side of a truck, when I die, this goes to Billy Bob, and the question is that a will? Is that a valid will, a testamentary gift that can be enforced? It's not clear. And so because of the uncertainty of the validity of holographic wills, we generally don't encourage people to draft holographic wills other than on a temporary basis and in an emergency. So for example, if someone's going to the hospital or something, they may write off in their handwriting a holographic will, but otherwise that's not the best solution. The third kind of will is a statutory will. They're created under Probate Code 6240. The language comes right out of the code section itself, and there are instructions on how to fill out the will. It's a form, and it has blanks, and you have to fill in the blanks. It has to be witnessed, and there are some formalities, but as long as you follow the instructions, there's no question that it will be considered valid. So in that way, it is much better than a holographic will, and it's inexpensive. It's just a form, so it's preferred to the attorney wills when it can be successful for someone, because the cost is so much less. For our clinic on Friday, these are the kinds of wills that we're going to be offering to prepare for people, and that you're going to be helping them prepare are these statutory wills. And in a few minutes, I'm going to get into more specifics about those, the wills themselves. But first, I want to just talk a little bit more about the background here. I've been talking about wills and intestacy and the distribution of the deceased assets through probate. But it's important for you to know, and thank you, you got the slide up there before I even asked for it, that not all assets go through probate at the deceased's death. Some assets transfer automatically without going through probate. And that's because the assets are held in a way that dictates who they will pass to on the owner's death. This can be assets held jointly in a way that dictates that ownership on the first death. For example, if assets are held in joint tenancy or in community property with right of survivorship, when one of the owners dies, it automatically gets transferred to the other owners. Some assets also transfer automatically without having to go through probate, because they're held in trusts, and the trusts will list the beneficiaries that the assets should passed to. There are also assets where there's a beneficiary designation in the title to the asset. So generally, life insurance, right in the life insurance policy itself, it'll say who the beneficiaries of the life insurance are, or IRA accounts or 401k and retirement accounts will generally list a beneficiary. And unless you fill them out and say the beneficiary is your estate, and so as long as you fill them out to say that it goes to a person or a charity, then it just goes out without having to go through probate. There are also assets in some bank accounts, some kind of bank accounts and brokerage accounts will have what's called a transfer on death to them. And that means that they include in the account itself a beneficiary designation. Here in California, in fact, we even have deeds that are transfer on death deeds, where within the deed it says who the beneficiary will be if when the owner of title on the property dies. So one thing that's important for you to understand and for the clients to understand is that these non-probate assets retain that character as non-probate, even if the owner subsequently creates a valid will or some other document. So a will doesn't override or change how title is held or a beneficiary designation. And it's important that you convey this when you're speaking with the clients, and we all convey this when we're speaking to the clients, because it's natural that they might think that the most recent document is the one that would override, but that's not going to be the case. If something is a non-probate asset, creating a will not make it transfer under the will or have it go through probate. So there's a potential we can see to be able to transfer assets and avoid probate. And that's a good thing. You know, while probate has legitimate goals that we mentioned, to be able to identify the property and transfer and make sure it goes to the proper beneficiaries, and that creditors get an opportunity to get paid, and guardians can get appointed. While there are legitimate reasons for it, there's a reason that probate has kind of a bad rap. And the reason is the probate process can take a long time and it can be expensive. So probate fees, in fact, can sometimes seem really unreasonably high. You go to the next slide. Probate fees are set as a percentage of the value of all the decedent's property, undiminished by debt. So probate fees can particularly be high when the individual has a lot of debt on that asset that is being, or those assets that are being probated. So for example, let's say that an individual owned one asset, a home that's worth $1 million, but it has $800,000 of debt on it. So there's only $200,000 of equity in the house. When that person dies, if it goes through probate, the probate fees could be as much as $46,000, you know, almost a quarter of the value of the asset in terms of the equity. And that, you know, understandably can seem like an unreasonable amount that is being paid in probate fees. And in Marin, and in fact, throughout the whole Bay Area, you find that's not uncommon, that particularly with a home, that you'll find that an individual can have one asset and it'll essentially be their only asset that they own. And it has a lot of debts on it. And if it goes through probate, it will be kind of an unfortunate situation. One way we can help our clients is to help them avoid having a full probate. And there's something in California called a simple probate, that if a probate of assets are under a certain cutoff, then the whole thing can be taken care of with just a filing of an affidavit. For this year, for 2022, that cutoff point is $184,500. So if the individual's probate estate is under that amount, there will be no no probate, no full probate. So one strategy in representing clients is to help them see ways to bring down their probate assets under that cutoff. And we could help them recharacterize assets as non-probate by changing title, for example, to being joint tenancy, if that might work, or to designate a beneficiary on an account or something like that. So that's one way that we can help them. Next slide. So turning back to the wills that we're going to be creating for this upcoming clinic. I'm not going to go through, because I know that we don't really have much time. We're trying to keep this really tight here. I'm not going to go through step by step through these wills. There are very good, clear instructions on how to fill them out. And if you have any questions, I'm happy to answer them. There are a few important things, though, that I do want to point out, and that's what I'd really like to spend my time on, is that the forms, as you'll see, they are forms. You have to fill in a blank or fill in a box. And the important thing to know is going through these forms that you can't add options, you can't add language, you can't delete language. If you do that, then it can just invalidate the entire will. And you can see, if we go through the next page, just to kind of show you what the whole will looks like. And you'll see, again, it just continues with these blanks and boxes. And you could do the next one also. Thank you. So most often, if there's going to be a problem with whether or not the will is going to work for a client, if there's going to be a problem so that they want to be able to add language or delete language, it's going to be on these first paragraphs 2, 3, 4, and 5. Those are the paragraphs where the individual indicates how she wants her property distributed. And you'll see with these, like here with this last page here in paragraph 5, you'll see that there are 4 options of groups of people that property can be distributed to. And it's the same with paragraphs 2 and 3 when it comes to, if you want to give a specific property of real estate, real property or personal property. And the 4 categories are: one is all to the spouse or domestic partner, and if not to the spouse or domestic partner, because the spouse or domestic partner has predeceased, then all to the kids or to the descendants of a child who may have predeceased. The second option is nothing to the spouse or domestic partner, and all to the children or to the descendants of a deceased child. The third possibility is all to one individual, and the fourth possibility is evenly divided among a number of individuals. So any other type of distribution that you want to make really won't work under the statutory will. So for example, if you wanted to give the property unequally to your children, say 60% to one child and 40% to the other child, you can't do that in this form. Even if there's a legitimate reason, even if one child has greater needs than the other child, if you're using this form, the only options are when you're giving it to a group. So like the remainder, if you want the remainder divided among people in a group, it has to be evenly divided among those people. So that can be a little bit difficult. It's with personal property, it's the same thing. So you can't say, I want my clock to go to one person, my friend so-and-so, and I want my car to go to another person. You have to kind of evenly divide the assets under these. So there is one provision where you can give specific gifts of cash of a certain amount, and you can give those individually to people. And so that can be one way that you can kind of roughly make things closer to what a client might want, but there are limitations to this. And if these categories aren't going to work for a client, it's possible the statutory will just won't work. And so sometimes there are clients that we just can't help with this document. You'll see also that I want to point out one other thing. If you go to the next slide, when it comes to nominating the executor, if you don't want if the client doesn't want his or her executor to have to post bond, then they have to make sure they sign in that box. And that's something that generally, if an individual has a family member or friend acting as executor, they would rather they didn't have the cost of that. So generally, they will want to sign in that box. And then the last slide there is on executing the wills. And so I'm not going to go over that again. The instructions are very clear on it. And also that is something that actually you all won't be doing. That's something that Gabby and people at Legal Aid will be actually helping people execute it. So if you have questions about that, again, I'm happy to answer them, but I'm not going to go through it. That's about it for me. I find that most people are tremendously appreciative of your help when you help them create a will. You're helping them deal with facing their mortality, and that's a tough thing to do. And so they're appreciative of the fact that somebody is there helping them. So I think that's it for me, and I'm going to hand it off to my other half of this Bonnie and Clyde team. So you, Clyde, okay.
Thank you so much, Bonnie.
Sure.
And thank you, Gabby, for changing the slide. All right, so now, we've talked to our client about the fact that maybe putting together a basic, simple statutory will is a good idea. And they've bought off on that. And so they've filled out the form that we just went through, naming their beneficiaries, naming their executor, and naming the other, identifying the other issues that need to be identified in that form. And so they have a sense of relief. So the next thing we need to talk to them about is, okay, well, now we've figured out what we need to do, or we've done what we need to do to prepare your estate for after you pass away. And as an aside, we're doing very simple wills here for the clinic. I mean, customarily, people will draft attorney wills and revocable living trusts to own their properties, especially if their estates exceed that $184,500 mark, so that they can be more detailed in what they want to have done, not only after they die, but during their life. And also they can escape the probate proceeding that Bonnie so nicely talked about. But so they have a will, and now we want to plan for the possibility that they could, at some point in their life, become incapacitated and not be able to make decisions for themselves. If they have a will only, that might be problematic, because if they do become incapacitated, there's nothing in writing saying what they want to have happen in terms of who should have their back, so to speak, for financial purposes, or for that matter, who should have their back in matters involving healthcare and medical decisions. And so if we can go to the next slide, what happens sometimes in those events is that somebody has to go to court and file a petition for a conservatorship, so that the court will appoint a representative or a conservator over the incapacitated person or the incapacitated person's estate, their money, so that matters can be handled on that person's behalf. And you'll see here a list of some of the more famous celebrity conservatorships. We've all heard about Britney Spears and the fact that she had some mental health issues a number of years ago, I think 13 or 14 years ago, and was placed in a conservatorship. Her father was the conservator, and there were legal battles going on back and forth between her and her father for quite some time, because she essentially got well and claimed that she no longer needed somebody to manage her affairs, manage her life. And evidently he was kind of going overboard with all of that. But I guess the good news for Brittany is that ultimately, about a year ago, the judge agreed that her father should be taken off as conservator and disbanded the conservatorship altogether. So Brittany is now in charge of her own money. Another example is Casey Kasem, who back in the day was a DJ and a radio personality, had the American Top 40 music countdown. He developed Parkinson's disease, and